Appeals Division 1 is now in session.
Good morning, you may be seated. Good morning. We are here today. Let me first say, for those that feel comfortable doing so, if you'd like to take off your mask for purposes of the argument, please feel free. We are here today for oral argument in CV 18-0154, Stuart versus City of Scottsdale et al. As you are probably familiar, each of you has 20 minutes to argue. You will be live streamed and recorded, so as you begin your argument, please introduce yourself and your client for the recording. You're responsible for keeping track of your time, and we realize we have made that more difficult for you because you will be arguing from council table and the timer is not there. Please feel free to keep an informal time at your table if you'd like. Feel free to move around as you need to look at the clock, and we'll try to give you some signposts here and there. Or feel free to ask, and we'll tell you how much time you have left. But you are still responsible if you'd like a rebuttal to save some of that time. Please do keep in mind that we have read the briefs, all parts of them. We have reviewed the record. We have conferenced the case and discussed it this morning. And so with that, bearing that in mind, please go ahead.
May it please the court, good morning. I am Scott Zwillinger, here representing the appellant in this matter. I'm going to reserve some of my time, somewhere between 5 and 7 minutes for rebuttal with the permission of the court. I appreciate the court's admonition of its review of the record and the briefs, and I'm going to try to focus, with the court's permission, on a couple of issues that, to me, as I was preparing more than 2 years after our trial concluded at a trip to bankruptcy court, that really underpin why this case is different than some of the other gift tax cases that have come before this court and some that are in front of the Supreme Court right now, and some of the errors that, with all due respect to Judge Kiley, that he made that require reversal. And the biggest thing that I want to point out to the court is that this case is different than all other cases that have come before it because of the existence of the Scottsdale City Charter. And even if we were to take the gift clause of the Constitution out of this case, out of existence, we would still be entitled to reversal. And in fact, when you review the plain language of the city charter, it is apparent that it is stricter than the gift clause, that it was written, obviously, much more closer to these times with more experience of governments and governments' interactions with private companies. And if we just look at the language, the plain language in there, it's apparent that it is more restrictive.
Do you have any cases suggesting that? Has this court or the fourth floor, have they ever held that the charter is different, or any charter city with similar language?
No, Your Honor, I'm not aware of any, but what I would point the court to, again, is simply the plain language. There are significant differences. Clearly identified public purpose, and talks about receives direct consideration substantially equal to its expenditures. So when we look at the prior case law, and we think that we win under the gift clause, let me be clear about that. And I'll obviously talk about the gift clause, but when we focus in on the city charter, it simply can't be ignored that the LMA, the Sixth Amendment to the LMA most particularly, violates it. And one of the things that we argued below was there was arguments of intent of what the politicians meant, the council meant when it was adopted, what the people meant when they voted for it, all those types of things. But all the cases that talk about when you get to intent don't really matter here because, again, you don't get behind the plain language of the city charter.
Let me ask you this, and a question I have. It seems to me the public purpose test itself is the same for both. Would you disagree? And I'll distinguish between that and what you may be arguing is the burden of proof as opposed to the public purpose.
Well,
are you arguing there's a difference in public purpose that needs to be proven?
No, I do argue that the word clearly identified requires that there to be something clearly identified, but that's effectively what the cases talk about under the Arizona gift clause. What we're talking more about, I suppose, is the substantially equal to language and the direct benefits language that admittedly has been read into some of the case law when analyzing the gift clause. but is apparent and clear when we consider.
But if it's part of the analysis that's used in the gift clause, I grant you that it's expressed there, which seems to reflect what the cases say. It is newer, as you noted. Isn't it, though, still then the same test?
Yes, the public purpose test, I concede, is the same test. And Judge Gass, if with your permission, I'll analyze why the city didn't meet its burden to demonstrate a public purpose as it applies to the Sixth LMA, the Sixth Amendment. And of course, that's because the reasons behind the evidence at trial as to why this occurred. This was not a situation where there weren't golf courses in Scottsdale for the general public. People were complaining about the facilities. What the evidence demonstrated is that the PGA, the Professional Golfers Association, came to Scottsdale and told them that course isn't hard enough for professionals. Folks with the innovations in clubs and things like that are driving 300, 350 yards. Course isn't long enough. There aren't enough sand traps and bunkers and all the kinds of things that when I play golf I regularly end up in, but it wasn't good enough for professionals. And then the other piece of evidence, of course, is that the facilities themselves weren't large enough, didn't have the ability to accommodate the tour pros and their managers and their masseuses and their agents and families and on and on and on. So that's not a public purpose. There's no need for, the people didn't have that need. A private company and their employees, and let's be honest, when we talk about professional sports, that the court can take judicial notice, we're talking big business, billions of dollars. In this pandemic, we've seen the effect of the shutdown of sports all across the economy. And so this was something that a big business and its employees, or maybe it's independent contractors, but it's people who are making money off of it, the golfers, were complaining. That's not a public purpose. And so right there, this case requires reversal because there is no public purpose. This wasn't anything that the people were clamoring for.
But a public purpose, Scottsdale was improving its own property. I mean, when you're improving your own property, you could argue that putting, a restaurant in a city building isn't for a public purpose, but it's the city's building and they decided to put a restaurant in it.
For the benefit of a private business, they did that for, not for the general public. And the evidence at trial was that
If a private business asks for it, but it also benefits the public, I mean, presumably members of the public have nonetheless enjoyed that golf course. I'm not a golfer, I know people who golf there. Is that somehow insufficient that members of the public didn't ask for it, but nonetheless benefited?
in this matter it is. And the reason why is, again, there was no evidence presented that attendance was public attendance, public playing at the course was trailing off. People weren't showing up. People were leaving bad Yelp reviews or whatever golfers do, that the course was failing down, and they were maintaining it. The course was fine. Revenues were fine. But the PGA, a very specific private user, was demanding changes for its employees, its professionals. And so there is a difference between a public entity putting a restaurant in Scottsdale Civic Center that every member of the public could go into, and when they...
But there were public benefits that flow from just having the PGA Tour there. There's TV broadcasting, there's publicity for the city, there's hotel rooms that get filled with it. There's a lot of public benefit just from the fact that the PGA holds that tournament there.
Well, respectfully, I think a lot of that is based on supposition by the city, the professional staff of the city of Scottsdale, and then presented to the council. Because at trial, when we examined how do we determine these values, the statements were there, the broad 30,000 feet statements of this benefits the public, this benefits Scottsdale, but the evidence wasn't there to support it. There was no science. And I would point this court to the recent case before this division. I may butcher their name, Shies versus Carlott, which is now on appeal above to the Supreme Court. And I want to talk about it factually, recognize it's not binding precedent, but factually it gives us some answers.
Can you give me the site for that?
Yes, of course. It's 2020 Westlaw 390671. 390671. And in that case, the city of Peoria was spending money, was reimbursing private universities one, I think one trade school, one a university, but whatever, private entities for their campuses. And now, admittedly, this court accepted what the public purpose was, but Judge Morse dissented. And I think Judge Morse's dissent, when he starts talking about, okay, these entities are building a campus out, costs $2 million or thereabouts, and then they're being reimbursed by the city of Peoria, well, there has to be evidence that that expenditure of money flows to the public.
Who owned the campuses?
I believe it is the private entities, but when I sit down, if I may, I'll review and answer your question when I come back up, if that's all right.
That would be, because I think that's a key difference, is that it's not owned by the city.
I apologize. I will answer that as soon as I can. When I get
You
back.
have 10 minutes, 45 left.
Thank you. And so when we look at that public purpose, and now one of the arguments that was also made that relates to, Judge Gass, your question about wasn't the city just renovating its own property? But again, it spent $15 million with contractors to improve its own asset. It's equivalent to the garbage truck analogy that, and the sewer pipe analogy that throws through our case law when we analyze the gift clause. If that costs $50,000 to repair your sewer pipe, obviously the benefit is much larger to the community, moving waste and preventing disease and those types of things. But that doesn't mean you can go out and spend $5 million for something that you can otherwise get for $50,000. And that takes me into my second prong, which...
But go back. How would they have gotten this $15 million improvements that they wanted to make? I mean, go to your sewer pipe example.
Sure.
Why would, okay, assume that somebody spent $50,000 on a piece of pipe to put on a $5,000 piece of pipe. Isn't that sort of an absurd example? I mean, is that reality that a city would spend $50,000 for a $5,000 piece of pipe? I mean, what translate to the actual facts here? Did they spend $15 million and they only got $5 million worth of improvements?
Well, we don't know what they got, because we do know that they spent $15 million to put $15 million into the property, but we don't know how that increased the value. So the example that I use, I believe in my briefs, but it may have been below, but
But is there any evidence that the amount spent did not translate? So what Judge Brown's point, the pipe is only worth $5,000, but you're spending $50,000 on it. That's $45,000 of waste. But it sounds like here there's two different things. The value of the actual improvements, was the cost at $15 million a legitimate cost versus what it brought in?
well, that's why we have a procurement code with dealing with public entities. We don't know. I mean, there are other entities that, and the evidence was a trial, that run golf courses. Troon, for example, and there were a couple of others. There was no competitive bid. How much will Troon contribute to this? If we bring them in, how much will this company? Okay, you know what? The PGA is reasonable. It's in that ballpark. There's your science. There's the evidence. There's the...
But failure to comply with the procurement code doesn't necessarily mean there's a violation of the gift clause.
I agree with Your Honor, but it's evidence of that something should have been done to determine, okay, we're going to spend this $15 million, which then the city decides to borrow money and pledge tax revenues to pay back instead of revenues from the event or from the facility itself. So it's evidence that there was no attempt to figure out, was this fair? Was this appropriate with the return? And what we do know is that what the city got back, it got back less than $3 million over the life. It got a TOR commitment that is completely illusory, starts with the statement there is no TOR commitment, and gives the PGA all kinds of outs. And then it also got supposedly free advertising. But the evidence was, this isn't the Scottsdale Open, it's the Phoenix Open.
Do we look at the gift clause or either of the two violations at the time that the council considered? So what information they had at the time they made the decision for the Sixth Amendment or the Sixth LMA? Or do we look at it based on subsequent evidence as to what actually came to be?
Well, I would suggest that we should look at it the date that they made the decision to accept the Sixth Amendment. Anything else suggests that the government officials could go willy-nilly, and then when they're called to task, start litigation backfill to justify their actions. That can't be what the gift clause means or the Scottsdale City Charter means, because that leads to absurdity. It just means everything is going to be litigated. And if I may go back to the TOR commitment for one quick second, and then I may reserve my time, when we brought up to the court and council that this tort commitment says there is no commitment and has a couple of little exceptions, the answer back, what the court found was, well, it's a contract. There could be a breach of the covenant of good faith and fair duty. You've got this recital here versus this clause here. So rather than a clear statement, if it's a tort commitment, it says it like it did in the previous LMAs. There is a tort commitment of X years. So the idea is that that fails because it can't be that something is a value and I just got to litigate it down the road to prove that I'm right in my contract interpretation and the PGA isn't. Think of what would have occurred here if the PGA decided to move the Phoenix Open from Scottsdale to New Mexico, and then the city of Scottsdale sued it, and then 2, 3, 4 years of litigation, and then it unwinds. That can't be. And that, again, it goes to your question, Judge Perkins, as to why the measuring date has to be the date that the contract is adopted. Anything else just puts it all on the risk of the outcome of litigation. And then one more moment, and then I'm going to reserve my time with permission of the court, is the advertising dollars that we talked about. Again, there's no science here. Yeah, it may be that mentioning Scottsdale, a pan at the beginning of a commercial or after a commercial break where it shows the beautiful mountains and isn't Scottsdale wonderful, come to Scottsdale, has value. But where's the evidence that that was done, determined? Where's the evidence that the announcers of the event had the obligation to, 3 times an hour say how great Scottsdale is? They didn't. I mean, they could go the whole tournament and never mention Scottsdale because, again, it's the Phoenix Open. So these, at the end of the day, I believe...
Making public policy determinations like this, is the city council, do they have to have evidence of what they believe to be true?
Yes.
It's a policy determination, right?
Well, it's not because of...
In terms of what they believe will benefit the city.
No, I respectfully disagree because of the fact of how consideration is analyzed in this area of the law. If this was a straight contract between private owner of the tour and private owner of the golf course, then consideration is very willy-nilly, as we all learned first day of contracts. But what the case law has told us that with consideration here, you have to look to objective fair market value. So again, you've got to gather the science, and that didn't occur here. With the court's permission, I'll reserve the remainder of my time. Thank you.
Proceed.
Is that okay for?
Yeah.
Oh,
Just make sure you get close enough and we can record you.
With the court's permission, I'm going to move this chair. Please, the court, Eric Anderson on behalf of the city of Scottsdale. There is a number of individually named, all of whom are employees or officers or elected officials of the city of Scottsdale. I won't repeat them here, but I represent all of them to the extent they're a party to this appeal. I want to kind of go back to when I was a much younger attorney and an old-time attorney. I was learning some trial skills from him. And one of the things he said to me, he said, there's a case that you were going to try, the case you did try, and the case you should have tried. And those are one of the wisest words any attorney, and that late attorney really imposed on me. There's always the case you thought you should have tried, but there's the case that you did try, and that's the case that this court here is looking at on this appeal. And why I think that's so important here is that there is almost a complete disregard for the record before the court in the arguments advanced in Mr. Stewart's brief as well as advanced by his counsel here today. The record just doesn't bear out that. So I'll start with the idea, and one of the things is, to Judge Gass's point, yes, public purpose is the same. The Scottsdale City Charter, we actually provided the legislative history, I will call it, for lack of a better word, because the charter amendment that council relies heavily on was actually referred to the voters by the Scottsdale City Council.
Let me stop you there. You say it's substantially the same. Help me understand that, because I thought under the Turkin case that the standard and its cases that before that you would have to show that the consideration was grossly disproportionate. Okay, under the arrangement. But in the language that Scottsdale has used, it says that the city receives direct consideration substantially equal to its expenditure.
Yes, Your Honor, and I apologize. I was referring initially to the public purpose question. The state constitution, if my recollection serves me, doesn't even mention public purpose. I think that's a creature of the
Right,
court.
right.
The court's
And I would
case.
agree with you that in my mind, they're substantially similar, if not the same.
Sure.
Okay.
And what the legislative history indicates is that the task force that referred this to the council for consideration to refer to the voters specifically based their language on the Turkin decision and said, yes, we want a little higher standard of substantially equivalent consideration, not equal consideration, substantially equivalent. And the one case I did find, I apologize, the name escapes me, but we did cite it in our briefs, says substantially equivalent doesn't mean one for one, it means generally equal. So yes, there is a slightly elevated standard between the grossly disproportionate or roughly proportionate that appears in the state constitution jurisprudence compared with the lack of jurisprudence. There is one case, it's unpublished, we did cite it, it's actually Stuart versus Lane, I call it Stuart versus Lane 1, it came to this court on another golf course agreement. The court another panel of this court did consider that and applied essentially the same language. I don't think the court needs to get hung up on that because the city met either standard. So
So take the higher one, because if
Right.
you meet the higher, then
Right.
you obviously meet the
So,
lower.
and I think what we tried to convey in our briefs to this court was forget about the state court standard other than the sense that that's really the case law to guide how you apply this. So a couple of things that council overlooked, though, is that first thing you do is there's a presumption that the city council, a legislative body, is acting constitutionally, or I'm not sure what the municipal equivalent for acting charterly or whatever that might be, but there's a presumption so council referred, and I think this is important, said they didn't meet their burden of this. Well, no, Mr. Stewart was the plaintiff. It's his burden to show that the agreement that he was challenging was illegal. It's not the city's burden to show that it was there. There's a presumption it was constitutional, but even if you want to apply that burden, there's a clearly identified public purpose in there. There was 4 different public purposes. Number one, as Judge Gass pointed out, is this is city property for the most part. Now, I will clarify because the record will bear out that there's actually a combination of city-owned property as well as property licensed to the city by the United States Bureau of Reclamation. The clubhouse that was improved in question is on city property, and the record will bear that out. But these are public improvements, and yes, the golf course is open to public improvement. So you can end the inquiry there, and Judge Kiley in his decision said, well, yeah, that alone probably ends the inquiry, but he didn't stop there. He went on, and he did the analysis, and he made findings of fact and conclusions of law. And those findings of fact are what this court accepts unless Mr. Stewart can show that there's no basis for those findings of fact. And when counsel says there's no evidence to support, that's simply wrong. The record is full of evidence of the value. So what did the city get from this? The city got, not only did it improve its own property, which it can do at its whim, that's what council debates and political debates are for. Should we have a nicer park? Should we have a small park? Those are political debates, not debates to be held in the courtroom, but in a council forum. But go past that. City got more money for what it spent. It got the commitment from the TPC, who operates the course, to give a 2.5% increase over the 10% of gross receipts that are already received for a period of roughly 20 years.
Council, how did those improvements benefit the general public? The average weekend golfer with a handicap way in the 40 or 50 like me.
Well, in and of itself, for the average weekend golfer, there's 2 aspects to that. It's a nicer course, so it's the equivalent of having a nicer park. Okay, so at the same time, also it also draws visitors because if you have a nicer course, you're drawing visitors. You're having a national draw. This is not just a local. This is a nationally advertised. And
So
it-
let me clarify. So the improvements were not just to the clubhouse. So if I understood opposing counsel's suggestion that there was changes to the physical nature of the course as well as part of the 15 million. Or
Indeed, there was. Correct.
So it's both for the clubhouse and
Both the clubhouse. There was actually, if you dig down deep, and I don't think this was necessarily a big issue at trial, if you dig down deep and look into the LMA, there's two separate combined components. One is course changes that they wanted to do to make the course more challenging. So to that extent, to the extent the public wants to play a more challenging course, that's that. And then there was a second set of improvements that expanded the clubhouse. The expanded clubhouse, I think, is for the tournament. That was part of the record, that the bigger club was to accomplish. And what I was getting to with that is not only is there an increased revenue share, there's two separate commitments. There's a tournament commitment, that's we will hold this event for an additional 10 years, and we will also televise the event for an additional 9 years. Judge Perkins brought up an interesting point about when do you do. I think, Judge, in answer to your question about when do you analyze, yes, you look at what the council decision was at the time and the available information at the time. But I think there's a second aspect to that comes into contract interpretation, and that's the case law tells us that you can look at the conduct of the parties post-agreement to understand an ambiguous clause or something that needs interpretation. And I think that's
But
where
to the extent we're looking at record evidence about what revenue or attendance or commitment of the tour, following through on the commitment by the tour, all of that evidence, even if it's in the record, doesn't really inform whether or not there was a public purpose, does it?
I don't think it informs.
Consideration.
I think the case law makes clear that it's a two-pronged analysis. Public purpose is question one under Turkin, and consideration is question two.
But also for the consideration, do we look at what bears out, or do we look at what is offered?
Your Honor, yes, Judge Perkins, you look at what was the available information at the time. Nobody knew, like, as we sit here today, and we were fortunate enough to be able to talk, not through a mask, but nobody predicted a pandemic, and the pandemic could legitimately have an effect on the last tournament that might occur in 2021. That is the television commitment. We just don't know. But you're right. You look back to 2012 when the agreement was made as to what the council. But I do think there is a component, and one of the points we made, because admittedly the ambiguous language about if there's a failure to hold the tournament, what happens, I look at that as a poorly drafted limitation on damages clause. So I think you do look at that, and the evidence in the record is that the PGA representative as well as the city representatives both said, yeah, our understanding was as they were committing to a tournament and televising that tournament, and it would only not occur if there was some failure beyond their control. So that's the evidence in the record, is why I emphasized, I think it's so important for this court to stay disciplined to the record, because
Well, can we really stay disciplined to the record given some of the omissions?
I'm sorry, Judge Gass.
As far as transcripts, some of the information that we don't necessarily have in the record?
Well, Your Honor, the appellant has a duty to provide this court with the record of the case. To the extent that the appellant failed to provide the entire record of the trial to the court, then the court makes a presumption that there's evidence in that portion that wasn't.
And that's what I was going for. It's not necessarily relying on the record. There may be a presumption for some evidence we don't have.
Certainly there is, Your Honor. Yes, I will. And I have to say it was very hard to follow because the appellant didn't. He put a large number of volumes of appendixes which were difficult to track, some of which would had evidence that were not introduced at trial. So the best yes, I think most of it's there somewhere in that 4 volumes in some way, shape, or form. One of the things that we did do is because there was a preliminary injunction hearing way back in 2014 that the record will reflect, some of the testimony that was provided at the preliminary injunction hearing was also designated as transcript testimony for Judge Kiley to review. So it wasn't read into the record, it was simply designated, it was a bench trial, so Judge Kiley just accepted that as transcript designation. So like when I referred to the PGA representative, that gentleman testified at the preliminary injunction hearing. He did not testify live at the trial in 2017, but his transcript of his testimony was offered through designations, which are reflected in the joint pretrial
Let
statement.
me ask a question, because we focused on the fact that most of, or a significant portion of the improvements were on City of Scottsdale property, but some were made to property that the City of Scottsdale leases. Does that make a difference in our analysis as to those improvements? Do we have to take a different look at that? In other words, treat it differently?
I don't think it does, Your Honor, because the evidence is that you have a long-term lease, or the BOR sometimes is touchy, they might refer to it as a license. So there's actually a separate document with them. It's called a land use license, I think, or something of that nature. But yes, those are publicly owned lands as well. But the right to use those lands, subject to flood control retention of rights by the BOR, is designated and licensed to the City of Scottsdale. So to some extent, yes, the course is that. I don't think it affects analysis. I will confess I couldn't find any case law that really got down in the weeds to that distinction between that. In the end, it doesn't really matter because Scottsdale didn't just rely on improving its own property. Scottsdale went and said, okay, if we're going to do this, you're going to provide us with some commitments in return. So one of the commitments that is beyond debate is the increased revenue share, which went from 10% to 12.5%, 10% to 12.5%. The parties valued that at roughly $4 million, depending on how you do the math, whether you project out increases on that. The figure that was presented to the council was $173,000 a year for 20 years. So, but on top of that, you had a second commitment for the tournament and the television. And there was evidence. In fact, the only expert evidence that valued it was said it was worth a lot of money. Both the expert David Wells, whose testimony was also provided by transcript, as well as our expert that we provided live, Elliot Pollack, provided an analysis. It's all set forth in there that this is worth a lot of money to the City of Scottsdale. So to Judge Perkins' point, yes, those analyses weren't available to City Council, but they served to confirm that the City Council wasn't just out there in the sky abusing its discretion trying to give away public money. They made a rational decision based on what staff presented to them, based on staff's own research into the thing. So, does that answer your question, Judge? I hope so. So we had, now the other thing that was mentioned briefly here in our oral argument was the question of whether or not there was a proper procurement. That really wasn't an issue. It was a Title 34 procurement. It's in the record that happened. Wasn't an issue that raised. There was a separate contractor paid. City got $15 million worth of improvements for $15 million.
Council, you have 4.5 minutes left.
Okay, thank you. And so that wasn't an issue that was raised in the briefings that I saw. But it is in the record again that to the extent it's a question that looms in this court's mind was, yes, Title 34, it's standard procurement, outside contractors were hired, money didn't go directly to the PGA, the money went to contractors to pay for improvements to a course. Now, the other aspect that I will say is that one of the stipulated facts was that the attendance at the event is over $500,000 per year. So council questioned, well, how do you know you're really getting? Well, 500,000 people, that's just basic math that the council can look at and say, well, yeah, we're a city that's in the tourism business, and therefore, if we have an event that's going to draw 500,000 people to it, which is over twice the population of the city itself, well then, yeah, that's going to draw people, that's going to draw money, that's going to bring economic benefits, that's going to bring exposure to our thing. And when we look at, if we look back at the record, that's exactly what Mr. Pollack, the city's expert, testified to. He said, yeah, these are extraordinary benefits to the city of Scottsdale, and what not only did they get what they paid for in terms of a better golf course and a better clubhouse, but they're getting all this on top of that. So not only to Judge Brown, your point, substantially equal, where I don't think you even have to worry about it, is because the evidence that was presented at the trial was that not only was it substantially equal, but the ledger was so a lot higher on the city side than anybody else's. So that question really is answered. What what plaintiff did in this case is he presented two people that wanted to talk about the history of the agreement. They wanted to turn the clock back to the 1980s and say back in 1980 you should have negotiated a different deal. Well, that claim was already thrown out on summary judgment. It's on appeal before this court. It hasn't been addressed here in oral argument, but I think it's clearly barred by the statute of limitations. But the experts so there isn't even conflicting evidence. The evidence that went to Judge Kiley at the trial was essentially that there is an overwhelming amount of benefits that flow to the city from this agreement. So.
Can I ask you just really quick about just to clarify for me, what happened with regard to attorney's fees? I understand that Judge Kiley awarded the Rule 68 failure to obtain a more favorable judgment sanctions. Was there any other fee award, and do I have that correct?
Your Honor, I do believe you have that correct. Yes, at the conclusion, the city did, after the preliminary injunction was denied, the city presented an offer of judgment that was more favorable. At the conclusion of the trial, when Judge Kiley found in favor of the city and dismissed the balance of the claims, the city filed a Rule 68 motion, set forth its expert witness fees and its costs. There was some briefing on that. Judge Kiley did rule that one of the expert fees was not recoverable. So the judgment was costs plus the Rule 68 sanctions. To my knowledge, there's no attorney's fees at this point in time. We did request
I recognize
attorney's
you have a
fees,
request. I'm just
yes.
trying to understand the landscape.
And I think that, to my knowledge, there's no attorney's fees awards appealed. It's strictly taxable costs and Rule 68 sanctions. So I have 40 seconds left. I'm glad to entertain any different questions the court may have, but I'm not going to raise any new points at this time. Thank you, Your Honors.
Just guess if maybe start with answering your questions that I want to come back. The property in the case that involves Peoria was owned by one of the plaintiff entities and leased to the other plaintiff entity. Also, you asked me about, I believe it was you, Judge, about other charter cases with city charters, and I would refer the court, it's cited in our brief, Jet versus City of Tucson, 882 P. 2nd, 426. Not on gift clauses, but it supports the idea that a city can have more restrictive requirements above the Arizona Constitution. I want to try to cover.
It ties into that. Then do you take any position on whether or not there is a difference between the improvements made to the City of Scottsdale owned land versus the City of Scottsdale licensed land? And what is that difference?
Not functionally for this case. I think both of them, neither one of them qualify, but there's no difference because of the 99-year lease. We're not saying that.
Okay.
And the reason that I don't think it's a distinction that matters in this case is because, again, this is expenditure not for the public. It's an expenditure of public money for a private for-profit business.
Counsel, you only have a couple minutes left, so I want to ask something that I forgot to ask earlier. Could you clarify what is your judicial estoppel argument?
Yeah, and that revolves around public purpose. And the argument was made early in the case, request for public documents, public records, and that was rejected. And the City of Scottsdale says, well, those are held by the PGA, so they're not public records. And the city was required under a good practice to obtain those records to show how much money they were getting, whether they were getting the proper allocation from the PGA, and then they would have become part of the public record. They didn't do that and said, well, it's not a public purpose. And then they turn around and argue that spending money on a clubhouse for tour masseuses is a public purpose. It's inconsistent. It's an inconsistent.
Did they say it was not a public purpose, or that was not that the PGA is not a public entity?
Well, the PGA is that the documents themselves were not public records
because they're not held by a public entity.
But they're for the benefit of the public entity to justify the amount of money. Okay. And I just want to quickly touch on as many things as I can in the time I have left. What we heard from Mr. Anderson, artfully, no doubt, but is that, well, there's all these great things that flow to the city. And no one will, it's a great event, it's a golf tournament, awesome. But there wasn't science presented at trial. And there wasn't science presented to the city council when it was approved. And if you look at the Peoria case that I talked briefly about, the court notes that they hired a valuation firm to value the property and the business. These are all quantifiable things, whether it's a tour commitment, which we think has a value of 0. We demonstrated evidence at trial that has no value, particularly because the language is illusory. Whether the advertising is that any city would pay for based on what they got, whether it has any value, that's all valuable, and they didn't do that. They relied on Dr. Wells, who of course recanted his testimony. And the reason the recanting is so significant is the Turkin case. Turkin talks about objective fair market value, because anything less than objective fair market value is subjective value, which then means that this court, or the people more accurately, are simply handing total discretion over to the city council. And that's not what the case law says. This court, for sure, we agree with Mr. Anderson. There's deference owed by all of us to the Scottsdale City Council. But we're saying that deference, give them the deference, but where's the science to prove their value? That deference isn't unending. It doesn't mean they just simply get to do whatever they want and we have to go, well, they were elected, vote them out next term. No. The case law suggests that these are things that there has to be science, value it, hire people. And when we talk about Mr. Pollack, I'm almost out of time if I may make this last point. Mr. Pollack, I would agree, is a well-qualified expert, but when you look at his testimony at trial, he just simply was a conduit to present evidence for Mr. Wells, which has been recanted, information that had to do with the greater metropolitan Phoenix area, not the city of Scottsdale. And so in this instance, his report demonstrated absolutely nothing, just like the presentation to the city of Scottsdale. May I have 1 minute to make one last?
No,
Okay.
thank you for your arguments,
All
counsel.
right, thank you, Your Honor.
We'll take this matter under advisement and issue our decision in due course. Court's adjourned.